Hi, Bill Henshaw here again, your friendly local constitutional kook, and with the latest news of the week. And whoa, wouldn't you know what it is? It's Derek Chauvin. You're out of here. Or are you? I think there's a lot to be seen in the next few months about this case. And I don't know. You were dealing with the just us system here, so don't count your chickens, as they say. So we will see. What I will tell you about this is if I was handling the case for Chauvin, he would have walked out of there a free man. And as astounding as that may seem, and as revolting as that may seem, you make the argument, like I can do in your case and have done in my cases, that California is not a state admitted into this union. Neither is Minnesota, coincidentally the last state admitted into this union, February 14th, 1859. After which this union, quote unquote, had been in a state of abeyance for 160 years, and we've been saddled with federal regional martial law rule. Now, none of those clowns there is going to make any of these kind of arguments. You're not going to see it. It's not how the system works, although it is. And to illustrate, the importance here, and this is one of the rare quotes I don't have from the U.S. Supreme Court. I wish it was, but I had a case in Montana, virtually next door, turn of the century, around 1904, when they were still taking the Constitution seriously, even though it hadn't been in effect for close to 25 years. And the judge, a federal judge, in dismissing a federal indictment for murder, said, and I quote here, excuse me, that, it's unfortunate that a murderer should go unwhipped of justice, but more unfortunate that a court without jurisdiction should exercise it. That's the proper perspective then. It is now. Probably a controversial decision in its day, although it shouldn't have been, as they clearly didn't have jurisdiction. So, that's the kind of argument I would have been making, and they never get past it because there's just nothing you can do. And by the way, you can send me an email, unincourt@gmail.com, about my modestly priced constitutional defense document packets, which includes an 84-page brief on admission of new states. So I don't say it unless I can say it with attitude and with authority, and you can do the same thing. Now, that said, excuse me again, goodness, um, coming to some other issues that are going to come up here, the primary one being the trial having been held in Minneapolis, and there's a very serious question whether one could get a fair trial there, quote unquote, and that could be reversible error. Then there's always the good old ineffective assistance of counsel, and they can cite that and almost make up reasons for it, as wild as that particular quote unquote right is. And there is no right, people. It comes from the due process clause of the non existent 14th War Amendment. Not there. No right to it. And it's so bad that the Circuit Court of Appeals, Fifth Circuit, I believe, actually ruled that defense counsel sleeping through large parts of a capital case in which the death penalty was imposed was not ineffective assistance of counsel. Case is called Burdine v. Johnson. Send me an email. I'll send you information about that case too. Email me, uwinandcourt@gmail.com. And that's how bad it is. I mean, there's virtually nothing there. If they can sleep through the trial, what the hell? Um, so there's all sorts of things there, and there's probably a lot of collusion in the background, with law enforcement thugs and the politicos there in Minnesota, trying to figure out a way to make it look good, and yet have Chauvin maybe do less time than Johannes Measurely did for murdering Oscar Grant out here in California. So we ain't there yet. We'll see what develops. And they can always fall back and say, well, the jury system worked, they did their job, but there were some legal problems, quote unquote, that caused the decision to be reversed. And if that happens, whether they end up retrying Chauvin is another interesting question, at least in the state court, quote unquote, which doesn't have jurisdiction. And if it goes into a federal court, it's even worse. It's totally removed there because all they have is civil rights. emanates from Section 1 of the non-existent 14th War Amendment. There simply is no jurisdiction there. And if you understand the perspective out there, people, you cannot use federal regional martial law rule like they're doing and have been for at least 160 years. That's given us much the worst of it here, that it makes it look good on the surface, like you're trying to get out there and help give equality to the freedmen at the time back in the 1860s. But that was never the intent. That was to make it look good and to get the votes. The real reason they had the 14th War Amendment was to make citizens out of artificial corporate entities, what I call birthright citizens. And no one who quote unquote ratified the amendment knew that that was the real deal there, and it wouldn't have been ratified if that had been made public. So that's how bad it was. And even worse, by the way, the 14th Amendment, for those of you that don't know, was presented to the same Southern legislatures that ratified the 13th Amendment. And they all rejected it in sufficient enough numbers to defeat it today, let alone in 1868. That's when Congress passes the Reconstruction Act of 1867 and replaces those legislatures with military legislatures. And they're the ones that ratified the amendment. But they couldn't have done it even under perfect circumstances, because if the intent was to make everybody equal, and it was, but not by raising up the freedmen to the level of lawful de jure jus sanguinis free white state citizens, that wouldn't have probably passed a single state at the time, but to reduce all of us down to the same level as undocumented enemy aliens, it reversed the relationship of at least the state citizens to their government from principal and agent to guardian and ward, or much more familiarly in the South, master and slave. And that's what they still think today. That's what it is we have to stop. We got to all pull together here, Americans, Africans, Asians, across the spectrum, and make them stop this divide and conquer BS they've been doing for at least 150 years, and go in there with the correct status, ask some real issues, and get things decided that they can't stop so easily, and mainly invoke our right to jury. That's the ultimate check and balance there is, because you get a jury that can rule on the facts and the law, and that's the way the system was ordained and established. That's what it is we want. Now we get past the bastards much more often than not, especially if you have educated jurors with the school system that teaches them things that they need to know. And they sure as hell didn't teach me 50 years ago. Nothing. They don't want us to know. And it's been that way for a long time. I have my grandmother's hand-me-down books, by the way, from the late 19th century. McGuffey 6, Appleton's 4th. And those things were a lot like what you would think of college textbooks today. There was some serious business being taught in the schools then. And people knew, and the system functioned a lot more like what it should be doing. That's what it is we need to get back to. So I've gotten a bit astray here with the Chauvin business, and certainly, by the way, the good news about this is if we were in the common law system we were supposed to be in, there wouldn't have been any problem convicting Chauvin for potentially first-degree murder with 25 years to life, or maybe even 2,000 volts. See you later. You just can't do what was done here to George Floyd, or anyone else for that matter, no matter what their color, race, whatever. You can't do this. And a big reason you can't, if Minnesota is not a state, then none of the laws are effective there. This idiot Chauvin wasn't acting in any official capacity. He therefore doesn't have any affirmative defenses, and he sure as hell doesn't have qualified, let alone absolute immunity from prosecution. That's the system we want to put back in place. That controls and may never stop some of these idiot cops out there. And by the way, just a question about this, people. Think about it. I don't know in this case or overall. I would love to see if someone did a serious study on this. How many of these cops, Chauvin included, are ex-military? And how many of them may have PTSD? And how many of them can't tell the difference between Baghdad, Iraq, and Berkeley, California? Now, admittedly, there may not be a whole lot of difference at certain times, but nevertheless, if you can't tell the difference between those two, and you think you're in a war zone, you're going to react that way. And that's what has to change. We get that one issue across and get proper training in place and get the territorial governor and or the president to perform their duty and the sworn duty to see the laws are faithfully executed, which among other things means that you don't treat you, I, or George Floyd like IBM or Chase Bank, a corporate entity. That's what's happening here because the cops are not being trained. So, wow, there's just so much going on here. So we'll see how events develop with the Chauvin case. Apparently, the sentencing is in a couple of months. That's going to be probably June. Yeah, maybe around Flag Day or close to Independence Day, quote unquote. And we'll see how that goes and what the sentence is. Because he could, in theory, get like 40 or 50 years. And, especially if they do it consecutively and not concurrently. But who the hell knows right now? I mean, it's just the justice system is such a mess. You can't make any safe predictions here. So yeah, the jury apparently, quote unquote, did its job. And I will observe, by the way, that the jury had 6 whites, 4 blacks, and 2 mixed race. And that probably doesn't happen in common law. That's an issue I invite your opinion on because I don't know if that goes along with being part of the political sovereignty of the United States or not. Certain things clearly do. Jury duty, I tend to think, is probably one of those. But I am open to opinion on both sides about this one. Please let me know what you think. Send me an email, youwinningcourt@gmail.com. What I will say about that and the issue of anyone, Asians or Africans or what have you, becoming our political equals is it only can be done one way consistently with the Constitution, not in contravention of it, which happened in 1868. And that's the root cause of most of the problems we have today. It is what it is. And I'm telling you, and I wouldn't, for example, go over to Beijing, China, and claim to be an American Chinese and expect to be considered a political equal over there. It doesn't work that way. So those are issues we sooner or later will probably have to deal with. I probably will not be around when that occurs. You never know. By the way, I am 72 and 73 later this year. And what I'm doing, I hope you can tell, energetic, passionate. My life is ahead of me at this age. That's astounding. And I'm trying to make up for the lost years I had when I didn't get taught in school what I should have. And I was so colossally ignorant there, people. What did I do? Volunteered into the U.S. Marine Corps at the height of the Tet Offensive. Story for another video, but trust me, that's how ignorant I was. That just didn't know a damn thing. So that said, we'll see what develops with Chauvin. Who knows right now? We'll just have to wait and see what path and what course this takes ultimately, and how the appeals courts, quote unquote, handle it. And if it reaches the U.S. Supreme Court, and this case could reach there, I don't know that it would. I'm not going to say it's a betting favorite, but it could happen. So that said, remember to send me an email, youwinningcourt@gmail.com, for information about my constitutional defense document packets. Subscribe, like the videos, tell your friends, get the word out. The quicker we all start to work together, the faster we get these bastards off our backs. Thank you.